Okay, we have one more presentation tonight. Board member prohibited acts and school ethics training by our attorney, Matt Giacobbe. They all yours?
Yes. There's one missing. We don't know where she is. No, she's a fast. Yes.
Wow, this is a really hard act to follow. I won't be singing, I won't be rapping, I'll just be talking to you about the School Ethics Act and the School Code of Conduct, Board Member Code of Conduct. This is the annual training that is required by state law that we go through, so that each of you as board members know the rules. What we have is we have an outline for you that's been updated, and what this outline does is it goes through the School Ethics Act and also the Board Member Code of Conduct, and we cite various advisory opinions and actual decisions of the School Ethics Commission dealing with the various aspects of the Act. So just so the board knows, the School Ethics Commission is an entity within the Department of Education, the State Department of Education, and they oversee the conduct of board members. They actually have two roles. One is if a board member violates the School Ethics Act or the Code of Conduct, they can hold a hearing and take action against the board member. It can go from a public reprimand, a censure, up to removal from the board. Removal is very rare, but they have done it. The other very important aspect of the School Ethics Commission is they issue advisory opinions. And they issue advisory opinions every month. They meet monthly and they issue advisory opinions. And so what I tell the boards I represent, and I've told you in the past, there's really nothing that you undertake as a board that is that urgent that we can't go and get an advisory opinion for you. The School Ethics Commission will not issue an advisory opinion if you've already taken action. So it's not one of these situations where you can take action and ask for forgiveness. What you have to do is if there's something that you think might be violative, you have a business relationship that somehow involves the board, you have a familial relationship, you want to be a member of the PTA and serve on the board, we can get advisory opinions prior to you taking any action so that you do not violate the School Ethics Act. So I'll give you an example. There was recently, there's a decision that I actually got as an advisory opinion back in 2000 where a member of the board wanted to know if she could serve on the PTA as well. The School Ethics Commission issued an advisory opinion in 2000 and said that was permissible. The issue came back up again in this certain town where somebody was alleging that you couldn't do that. So what we did is we asked for another advisory opinion, and the School Ethics Commission said, we told you in 2000 you could do it, and in 2018 you can still do it. So it's helpful. We had, if you recall, a number of years ago, we asked for an advisory opinion, I think I told you about. We had a school board member who was officiating school sporting events. And they didn't get involved with East Brunswick, but they were concerned that if they were at a county or a statewide meet and East Brunswick students were coming before them and they were going to officiate a swim meet or a gymnastics event, would that be a violation? They asked beforehand, we got an advisory opinion, and the School Ethics Commission said that would not be a violation. The main issue that board members have to, I'm just going to touch on a few things, and then you can go through the ethics opinions, and you can also go to the DOE School Ethics Commission website, which is under the DOE website, and you can look up all their advisory opinions. They have them there. But the main gist of this is that your job as a Board of Education is to make sure the schools are well run, not to run the schools. That's why you hire people like Dr. Vleski, Bernie Juliana, Joe Crotchfeld, Tara. They run the district, and it's your job to make sure that they're well run. One of the key fundamental facets of a board to make sure that it's well run is you work on and prepare the budget, you pass policies that the Dr. Vleski and the staff have to comply with, and you constantly revise those policies to make sure that people are following it. The reason that the law is a little bit different for school board members as opposed to town officials is that very often, school board members have children in the school. So the legislature, when they passed the laws, they wanted to have the board one step removed from the day-to-day operations. They didn't want to have parents of students making decisions running the district. And that's why they put in folks, in the law says that the person who does all the hiring is Dr. Valesky. He has to make all the hiring recommendations to the board. You don't have to always agree with him, but board members can't go out and say, well, you know, we want to hire a different BA, or we want to hire a different math teacher. That's Dr. Valesky and his staff's expertise to run the schools, and it's your job to make sure that he's running them well. And that's why one of the most important things that you do as a board is hiring a superintendent, evaluating the superintendent, because that's the individual that you hold accountable for making sure these districts are the district's well run. The areas that board members are getting in trouble the most often are wrongful disclosure of confidential information. A Board of Education, in this Board of Education, every meeting we have, we always go into closed executive session. I've never been at a board meeting where we haven't gone into closed executive session. And in closed executive session, there are mandates about what you can and can't discuss. It's very limited. Contract negotiations, personnel. In the context of schools, a lot of what's discussed in closed session is personnel and student-related matters. And student-related matters and personnel are confidential. Under state law, personnel matters are confidential. Under state and federal law, student matters are confidential. So that's why when we have HIB or harassment, intimidation, and bullying hearings, it occurs in closed session. When we have student disciplinary matters, it occurs in closed session. When we have personnel issues, whether it's some type of medical leave or discipline or discussion about evaluation of personnel, it occurs in closed session. Why? Because the law demands that we keep students' records confidential and personnel records confidential. The whole goal is that we don't want to wreck people's reputations. We don't want to bring them shame and embarrassment. And Board of Ed members are privy to very confidential information. You're privy to confidential information about students' medical needs, discipline, familial problems, and you're privy to staff members' very private information. And so when board members get in trouble, it's when they disclose information that is confidential, that only they are privy to. And so it's an awesome responsibility, and that's what you're entrusted with, and the law is specifically designed to make sure that those disclosures don't occur. The other area where board members are getting in trouble, and it's not just board members, it's public officials, and you can just read about it in the paper. It happens almost on a weekly basis, is the use of social media. When I say use of social media, it's emails, internet, Twitter, text messages, because when you are sitting on a board, anything that you write that involves the Board of Education is a governmental record. Anything. If you write an email to Dr. Valesky about the cancellation of a board meeting, that's a governmental record. And what people write on social media or in their emails or texts, those all have to be captured and maintained by the business office, in which you do. And where this becomes problematic is there's another law in New Jersey called OPRA, the Open Public Records Act, which gives anybody the right to access governmental records. And there's very limited exceptions as to what you can't disclose. So you can't disclose attorney-client privileged communications. You can't disclose confidential personnel records, disciplinary records. You can't disclose student records. But emails between board members on topics that don't involve those items are disclosable. And what's the other law that people have to be cognizant of, which has another acronym, is called the Open Public Meeting Act. In the Open Public Meeting Act, we're here tonight at an open public meeting. This meeting had to be noticed at least 48 hours in advance in your official publication so that the public could be here. It's televised, you have an agenda. And what happens is when board members start communicating via email, or it is happening much more now, not here, but in other districts, and I've been involved in some litigation over it, where they are using text messages. And when you have more than 5 members of this board communicating via email or text or on Facebook or any of these social media sites that are out there, If more than 5 members are communicating and it's involving board business, that's a public meeting. And if it wasn't properly noticed, that's a violation of the Open Public Meeting Act, and it's the county prosecutor that oversees violations of the Open Public Meeting Act. So what I caution board members to do is, if you're going to communicate, never, ever, ever send out an email to everybody. That is inviting disaster, because all you need is one person to hit reply all, and you've now violated the Open Public Meeting Act. If you need to communicate, it's better to communicate one-on-one. If President Becker needs to communicate with everybody, what I would suggest that she do, and I've said this in the past, is you blind copy people. If you send it out blind copy and somebody hits reply all, you're not going to blind copy back to people. The other very important thing to remember is that you should only use your official email address at East Brunswick. That's to protect you and your privacy. You don't want to you do not want to have board business being intermingled with your private businesses, your employment, or your private personal emails. Because if an Oprah request comes in, or there's litigation, and we have to go about and gather these records, it's much easier for Mr. Juliana and his staff to go to the district's website or database and collect those emails. And there have been cases where there have been communications among board members using Gmail or Yahoo or other private providers, and the board has gotten in trouble because the business custodian, who is Mr. Juliana, didn't disclose those records. Well, he can't disclose what he doesn't have, but if there are communications on another server that dealt with board business, they're governmental records. And the danger of the Open Public Record Act, not the Open Public Meeting Act, the Open Public Record Act, is if somebody files an Open Public Record Act lawsuit in court or before the Government Records Council and they prevail. What that means is, I filed the suit, you had government records that you didn't produce that I know are out there, and it turns out that there were records on Gmail or whatever that you guys had that weren't produced, the district has to pay the other side's attorney's fees. And these can be gigantic. There's a town in Middlesex County several years ago who turned over the records in the wrong format. They turned them over in a PDF format. Gannett wanted them in an electronic format. They resisted. They lost, and then they paid about $600,000 in legal fees. So it's very, very important that you use your emails, that you on the district, that you communicate. And what I tell folks is, Alexander Graham Bell had this great invention. Pick up the telephone. It's a good way to communicate with one another. And it's most people would realize you're not going to have a conference call with multiple people. And use the telephone if you want to have a conversation with the board president, the vice president, Dr. Valesky. That's a good way to communicate. What I would suggest is that if you have a specific question about any of your conduct or you're concerned about something, ask Dr. Valesky, ask President Becker. They can then reach out to me and we can give you an opinion. Generally, I can give you an opinion on whether or not you can do something or not do something based on advisory opinions, because we have access to all that. But if it's something that there's not an advisory opinion on, we can then ask an advisory opinion. It takes about 4 weeks for them to generate an advisory opinion if you catch their meetings right. So that's the school annual ethics training, and I'm glad to answer any questions or make myself available if people have individual questions afterwards.
Anybody have anything now?
Thank you.
Thank you so much, Matt.